Hello guys and gals, this is Christopher Mosier from My Media Helper, and I want to talk about an issue that I've been thinking about a lot lately, and that's usually how these videos come about. I haven't posted that much in 2026 so far due to time spent on other YouTube channels and working, but I thought this was an important video to put together. These news stories drive me nuts in some small way, and I suppose that is a simple and short drive to Nutsville for me. Considering this is mostly a technology channel, this is a good subject to vent about, and I will be venting full force because the whole situation is totally ridiculous. I'm talking about the recent court case involving a young lady suing social media companies claiming their addictive platforms and causing her considerable mental anguish due to their addictive tactics.
This morning, social media on trial, with a number of tech titans facing multiple legal challenges. Instagram owner Meta now on trial in New Mexico, accused of failing to keep kids safe from harmful content and online predators.
The culture at Meta is not safety first, it's brand first.
While in Los Angeles, a landmark lawsuit against Meta and Google, accusing the social media platforms of knowingly designing addictive products that could harm children.
The lawsuit is absolute bullshit, and in my opinion, a money grab. The lawsuit sets out a dangerous precedence for other morons to sue social media or other tech platforms for their own issues or for monetary conveniences. The lawsuit once again shows people in this country have a lack of self-control and personal responsibility, and once again, as I discussed in a different video that I will link in the description, parents can't do their jobs when taking on the responsibility of having children and fucking parenting. I'll be bitching about all these points later in the video, but for now, let us review exactly what I'm talking about if you're not yet familiar with the case. A young woman identified in court documents as K.G.M, or sometimes Kaylee, is the plaintiff in a landmark 2026 Californian bellwether lawsuit against major social media companies, alleging that their algorithm designs are addictive and caused her severe mental health issues. A bellwether lawsuit is a test case used in large groups of similar lawsuits to help predict how future cases may unfold. In large, consolidated litigations often involving thousands of plaintiffs, a small number of representative cases are selected to go to trial first. These early trials serve as bellwethers, like a bellwether sheep that leads the flock, because their outcomes give all parties, plaintiffs, defendants, courts, and insurers, an indication of how strong the claims are, how juries may respond to evidence, and what settlement values might look like for the remaining cases. Bellwether trials do not decide other cases automatically, but they strongly influence later negotiations or legal strategies. We'll get into the specific key details regarding the cases as of February 2026 of K.G.M versus the social media giants. The case is part of a larger Judicial Council coordination proceeding, often referred to as JCCP 5255. Let's discuss JCCP 5255 before we get into the K.G.M case. JCCP 5255, which stands for Judicial Council Coordinated Proceeding number 5255, is a major coordinated action in the Supreme Court of California, County of Los Angeles, involving thousands of plaintiffs who allege that major social media companies designed their platforms to be addictive and caused serious mental health harms, particularly among minors. In my opinion, the same case could be made for video games, or television, or eating, or 1,000 other things, and there have been court cases for all those. There have been multiple lawsuits that have been filed against major video game companies, alleging that their video games are intentionally designed to be addictive, particularly for minors. These ongoing emerging legal cases claim companies use predatory, addictive, and negligent design features such as loot boxes and reward loops that exploit developing brains. I'm going to stick to the subject at hand, but this has been done before by people who lack self-control, want a money grab, or can't parent their fucking kids. What about alcohol? Alcoholism is a national crisis, yet there's a liquor store what seems to be every 500 feet from each other. No one is forcing anyone to drink alcohol, and no one is forcing anyone to go on social media. Back to the subject at hand, JCCP 5255. The defendants have included Meta, which include Facebook and Instagram, Google, which owns YouTube, Snap Incorporated, which is Snapchat, and ByteDance, which owns TikTok. Some defendants have settled in particular bellwether cases, Snap and TikTok in the K.G.M case, but they remain defendants elsewhere within the JCCP, and we'll touch upon that stupidity later in the video. As you can tell already, I think this whole thing is fucking insane. The key allegations: the plaintiffs contend that the platforms were deliberately engineered to be addictive, borrowing mechanisms from gambling and tobacco industry behavior models. Specifically targeted minors to cultivate long-term user bases. As my sidebar, the same argument can be made for anything. Children's cartoons, commercials, movies, books, and the bullshit can go on and on. Continuing the JCCP 5255 allegations that social media is designed with features such as infinite scroll, autoplay, reward loops, and algorithmic engagement systems, allegedly shown to contribute to youth mental health issues, including addiction, depression, anxiety, and sleep disruption. The lawsuits argue that these design choices amount to wrongful conduct separate from protected third-party content, meaning Section 230 should not shield the companies from liability. Courts have agreed in several rulings. Section 230 is a provision of U.S. federal law, specifically 47 U.S.C. 230, part of the Communications Decency Act of 1996, that grants broad legal immunity to online platforms for most content posted by their users. It is often described as the law that made the modern internet possible. The central rule found in Section 230 says, "No provider or user of an interactive computer service shall be treated as the publisher or speaker of any information provided by another information content provider." Section 230 in JCCP 5255, what the court has said and why it matters. Section 230 of the Communications Decency Act normally gives internet platforms broad immunity from liability for harms that arise from third-party content. In most litigation, companies like Meta, Google, Snap, and ByteDance argue that claims against them are barred because they are merely intermediaries, not creators of the harmful content. However, in JCCP 5255, the courts have repeatedly rejected Section 230 defenses. In multiple rulings, the Los Angeles Superior Court concluded that the plaintiffs' claims do not target the platform's hosting of user-generated content. Instead, they target how the platforms are designed, the algorithms, interface choices, reward systems, notifications, and addiction-oriented features. In September of 2025, the court explicitly held that Section 230 protections do not apply because the claims are about design features, not content. Similarly, in the November 2025 summary judgment rulings, the court rejected broad immunity arguments under Section 230, stating that the platform's design choices could be considered independent wrongful conduct. This signals a major legal shift. If design-based claims escape Section 230 protection, many other types of cases could potentially circumvent the statute by reframing content-related harms as design-related harms. The plaintiffs presented scientific evidence to show that platform features like infinite scroll, autoplay, and algorithmic reinforcement loops are addictive by design, especially for minors. The court found this evidence sufficiently credible to proceed. The scientific methods and long-term studies supporting this claim were accepted. The platform's internal documents also corroborated knowledge of addictive design, since the alleged harms arise from the company's own conduct rather than user content. Section 230 immunity does not block these claims. This strengthens an emerging legal theory nationwide that algorithmic design and engagement maximizing architecture can be the basis of liability separate from content moderation. Before the expert evidence litigation, the court ruled that individual personal injury plaintiffs in JCCP 5255 have viable tort claims despite Section 230. However, claims by school districts for indirect economic harms were largely rejected, though for traditional tort law reasons rather than Section 230 specifically. Direct victims alleging personal harm from platform design may proceed. Third-party institutions claiming secondary harms face stricter limits. JCCP 5255 is one of the first large-scale cases to test whether addictive platform design is exempt from Section 230 immunity, and the court has repeatedly allowed such claims to proceed. The national implications include encouraging more lawsuits against social media companies framed around design defect, failure to warn, or negligent product engineering, potentially reshaping how platforms architect engagement mechanisms, especially for minors, creating a path to liability even when the harm involves communicative environments normally shielded by Section 230. These rulings mirror increasing federal scrutiny and could influence future legislation or Supreme Court review of the limits of platform immunity. JCCP 5255 shows that Section 230 is not a catch-all shield. Across multiple rulings, the court made clear platforms may still be immune when claims target content, but they are not immune when claims target their own actions, including design choices that allegedly cause foreseeable harm. This includes claims for addiction, anxiety, depression, eating disorders, sleep disruption, and other youth mental health harms linked to engineered engagement mechanisms. The implication is this framework could become a model for litigants nationwide seeking to bypass Section 230. Major judicial rulings in JCCP 5255, expert testimony allowed, happened September 2025. In a significant ruling, the court denied the defendants' motions to exclude expert witnesses, allowing testimony in psychiatry, neuroscience, pediatrics, and media psychology. The court held that the plaintiff's expert used accepted scientific methods. Section 230 does not bar claims that focus on design features, not content. The evidence showed platform designs were plausibly linked to alleged harms. This ruling substantially strengthened the plaintiff's ability to present their case. November 2025, summary judgment denials. Judge Caroline B. Call denied motions for summary judgment filed by Meta, Google, Snap, and ByteDance in 3 bellwether cases: Moore, K.G.M, and RKC. The court found plaintiffs presented evidence that design features like infinite scroll, notifications, and reward systems could cause the types of harms alleged. Section 230 and First Amendment defenses did not defeat the claims at this stage. Only one narrow claim, failure to warn against YouTube in RKC, was dismissed. All others moved forward. These rulings enabled the first full jury trials on social media addiction to proceed. School district complaints from 2024 rulings. Public school districts also joined the JCCP, alleging the platforms caused widespread student mental health problems that strained school resources. However, the court held that traditional tort principles generally do not extend liability to indirect third-party economic losses, and school district claims face substantial legal barriers. This is documented in the June 2024 California Superior Court opinion of demurrers and motions to strike, which emphasized limits on liability to avoid indeterminate exposure. Independent legal analysis noting similar challenges in dismissals of school district claims. The bellwether trial activity from late 2025 to early 2026. Actually, today as I record this, the first personal injury trials are underway. The case we're specifically talking about in this video is K.G.M. versus Meta/Google, a case involving a young woman whose social media use began at age 6. I ask again, where does the parent's responsibility lie for a 6-year-old to get to the level of social media addiction, or any other addiction for that matter? Why is a 6-year-old even allowed on social media? Why were there no limits of use? Where is the parent's accountability? I need to play this video I played in a previous YouTube opinion piece. That should be the end of it.
I think modern parenting over the last 20 years has softened so dramatically that many parents are mad at TikTok and Instagram and social media without realizing they have 100% control of deleting it off their child's phone. They have 100% control of taking their child's phone away for a month if they choose to. So guiding my children, for me, it's actually paying attention and caring to what they're consuming. I think parenting in 2023 has become too passive, has been too conducive to being your kid's friend instead of your kid's parent. And I would argue that until we get back to full accountability, we will continue to blame politics, the mainstream media, social media, TikTok, Facebook, and we're blaming, yet every parent that's watching this right now has control because they're the parent. So my point of view on this is parents need to step up in a significant way, be willing to be inconvenienced of their child being upset with them, and actually parent.
Always amazes me the accountability of the parent is usually null. Why JCCP 5255 matters? This litigation is historically significant because it represents one of the largest coordinated legal efforts ever targeting social media design practices. The first set of jury trials to test whether platform design rather than content can constitute accountable harm under tort law. A potential watershed for how youth mental health impacts are evaluated in relation to digital platform design. If plaintiffs succeed, the result could influence platform design standards, regulatory approaches, liability exposure for digital services utilizing engagement-driven algorithms. Section 230 of the Communication Decency Act normally gives online platforms broad immunity from lawsuits related to content posted by users, but in JCCP 5255, the California Superior Court repeatedly held that Section 230 does not bar the plaintiff's claims. This is one of the most legally significant aspects of the litigation. Section 230 protects platforms from liability as the publisher of content created by another person. However, the plaintiffs in JCCP 5255 argue that the companies harm them through their own conduct, specifically the design of addictive product features such as infinite scroll, autoplay, algorithmic recommendation loops, push notifications, reward systems. The court agreed that these claims do not aim at third-party content, but at the platform's own engineering choices. Therefore, Section 230 does not apply. The September 2025 ruling explicitly held that Section 230 protections do not apply because the experts focus on how the platforms are designed, not on user-generated content. The November 2025 summary judgment rulings likewise rejected broad immunity arguments under Section 230, holding that plaintiffs presented evidence that design features could cause the alleged harms. This distinction, design versus content, is the core reason Section 230 defenses fail in JCCP 5255. The court found that the plaintiffs offered substantial scientific evidence showing that design features can contribute to harms such as addiction, anxiety, depression, sleep disruption, eating disorders, body dysmorphia. The court held that these harms stem from companies' own actions, not from speech of third-party users. Plaintiffs' experts were allowed because they used trusted scientific methods and examined design-level effects. The court determined that the design features were capable of causing the type of mental harms allegedly suffered. Under this reasoning, Section 230 immunity is irrelevant because the alleged wrongdoing does not stem from publishing decisions. Section 230 states that a platform cannot be treated as the publisher of third-party content, but it does not shield defective product design, negligent engineering, failure to warn claims about risks arising from the platform's own features and business practices unrelated to content and moderation. The court reinforced this distinction by allowing the JCCP 5255 personal injury claims to proceed while dismissing other claims, like certain school district economic loss claims, on traditional tort grounds. The court previously held that individual personal injury plaintiffs have viable common law personal injury claims, although not for recovery based on defendants' publication of third-party content. This demonstrates the court's consistent view. Section 230 does not eliminate liability for the company's own conduct. JCCP 5255 is a key test of the limits of Section 230. These rulings make JCCP 5255 one of the most important cases to probe how far Section 230 immunity stretches. They show that Section 230 immunity largely collapses when plaintiffs allege product design harms, not content harms. A platform may host user content, but if its interface and algorithms cause harm, Section 230 does not necessarily protect it. The November 2025 rulings further confirm that whether platform design caused addiction or other harms in a factual question for the jury, meaning Section 230 cannot resolve the case at an early stage. This is extremely significant for future litigation nationwide. The court's approach creates a roadmap for future plaintiffs, frame claims around design features and algorithm architecture, show harms arising from the platform's own engineering decisions, separate from these harms from an argument about what users post. Because the court repeatedly affirmed this logic, JCCP 5255 may become influential in shaping how courts distinguish between immune content-based claims and non-immune design-based claims. This marks a potential narrowing of Section 230 without any new legislation. So in summary, and to reiterate, Section 230 does not protect the social media companies in JCCP 5255 because the claims focus on their own product design choices, not on third-party content. The court repeatedly rejected Section 230 defenses, allowing the cases to move forward toward jury trials. How does the court in JCCP 5255 treat the concept of addiction based strictly on what the rulings and reporting actually say? The court has not provided a formal medical, statutory, or standalone legal definition of addiction. Instead, the court evaluates whether specific platform design features are capable of causing the types of harms the plaintiffs describe. Harms that include addiction-like behavior. Here is what the court does say and how it frames addiction in the case. The court treats addiction as a type of mental health harm allegedly caused by platform design. In multiple rulings, the Los Angeles Superior Court acknowledges that plaintiffs allege addiction as one of several serious mental health harms. These harms are linked to design elements such as infinite scroll, autoplay, notifications, and reward systems. The court states that these design features were capable of causing the type of mental harms allegedly suffered, which include addiction. This shows that the court evaluates causation, not definition, accepts addiction as a plausible harm based on scientific evidence presented, but it does not articulate a definition like those used in DSM-5 or addiction psychiatry. Expert testimony frames addiction as a behavioral neurobiological response to platform design. When ruling on expert evidence, the court allowed testimony from experts in psychiatry, neuroscience, pediatrics, and media psychology, concluding that their methods were valid. These experts argue that social media design uses behavioral conditioning mechanisms, reward loop structures, compulsive use reinforcement patterns. These are described as similar to those used in gambling or cigarette industry tactics. Although these experts describe addiction mechanisms, the court does not issue its own definition. It simply finds the testimony reliable enough for a jury to consider. Plaintiffs' allegations about addiction. The plaintiffs allege that companies intentionally designed and built their social media products to be addictive, embedded features explicitly aimed at maximizing youth engagement to drive advertising revenue, used behavioral and neurobiological techniques similar to slot machines in tobacco marketing, and these allegations describe addiction as compulsive use abuse, inability to disengage, escalating psychological harm. However, these are plaintiff allegations, not adopted legal definitions. Addiction is part of a cluster of harms, not a separately defined term. In summary, judgment rulings, the court lists addiction alongside other mental health harms such as anxiety, depression, sleep disruption, eating disorder, body dysmorphia, and recognizes that plaintiffs presented evidence that platform design could cause these. Again, the court does not define addiction, just acknowledges it as a recognized type of harm that may be caused by the defendant's design. Bottom line, what the court actually does, the court does treat addiction as a mental health injury relevant to tort law, evaluate whether platform design features could plausibly cause it, allow expert testimony explaining addiction mechanisms, allow juries to decide whether addiction occurred and whether design caused it. The court does not provide the formal definition of addiction, adopt a DSM-5 clinical or statutory definition, create a special legal category of addiction for this litigation. So at this point, we have now come full circle, but before we get into the specifics of the actual case, I just want to throw this out there. There is a level of personal responsibility, common sense, and education with all things in life. If you're 6 years old, a parent or guardian is there to provide these tools and to educate you with those tools. If you're an adult, you're old enough to already have these tools. As an adult, government, society, or the next door neighbor is not there to hold your hand. That's not their job. As an adult, you need to realize when you're being targeted and act accordingly. I've personally known this since I was a teenager. I knew watching G.I. Joe opened me up to being targeted and advertised to by corporations trying to sell their products. I knew the infomercial at 2 a.m. in the morning was targeting people to part their money for ridiculous products. Even as a teenager, I'm talking 13, 14 years old, I got the fact movies and television existed to make money. Advertising was targeting certain demographics based on the show you were watching. Comic books had ads. I read comic books all the time. They had ads. I was advertised to. He-Man and Transformers were elaborate toy commercials. My Atari magazine was there to sell me video games. Same is said for Google and Amazon.com and social media. If you have Brain One in your head, you can put the pieces together and see their advertising products to you based on your searches. Now, you can simply close Google, close social media, go take a fucking hike and leave technology alone. That is your decision. That is your personal responsibility. This shit has been happening since the printed page, and now we have these stupid, frivolous lawsuits like the one I'm about to discuss to shift blame from personal responsibility to companies doing the same thing companies have been doing since there have been companies. I'll touch on more of this later. I just wanted to get that off my chest. Let us proceed to the main case. JCCP 5255 is the Judicial Council Coordination Proceeding in Los Angeles County Superior Court that consolidates thousands of personal injury lawsuits against major social media companies, Meta, TikTok, Snap, and Google. The case known as K.G.M. is the inaugural bellwether trial chosen from this larger group to go to trial first, with its outcomes expected to influence settlements for the rest of the cases. Here is how JCCP 5255 ties into the K.G.M. case. Representative Bellworthy trial. K.G.M., a 20-year-old plaintiff, alleges she suffered from addiction and severe mental health issues starting from age 6 due to YouTube, Instagram, and other platforms. As part of JCCP 5255, her case was selected as the first to go to trial to test the strength of the arguments regarding platform liability, shared evidence, and legal theories. K.G.M.'s lawsuit is built upon the same legal arguments developed in JCCP 5255 that social media platforms are defectively designed to be addictive and harmful to minors. The trial utilizes a shared evidence base, including internal documents from the broader JCCP. Overcoming procedural hurdles. In September 2025, Judge Caroline B. Call ruled within JCCP 5255 that expert testimony could be used to show how platforms platforms cause mental health problems, which directly allowed the K.G.M trial to proceed with robust scientific evidence, setting precedent for others. The results of the K.G.M trial are likely to set the stage for settlement negotiations for the remaining thousands of plaintiffs in JCCP 5255, which include other youth, families, and school districts. While Snap and TikTok reached settlements in early 2026, K.G.M's trial against Meta, Instagram, and YouTube, Google, proceeded as the lead case in the JCCP 5255 proceedings. The trial began in early 2026 in Los Angeles County Superior Court, marking a significant first-of-its-kind jury trial where tech giants, specifically Meta and YouTube, face allegations of causing youth mental health harm. Defendants, while the suit initially included Meta, which controlled Instagram, TikTok, Snapchat, which is Snap Incorporated, and Google, which controls YouTube, Snapchat and TikTok settled with K.G.M just before the trial began in late January of 2026. Key testimony: Meta CEO Mark Zuckerberg and Instagram head Adam Mosseri, or however you pronounce his name, testified in the case, arguing that the company is not responsible for the plaintiffs' mental health struggles and that their products did not lead to addiction. Defense arguments: lawyers for the tech companies have argued that K.G.M's mental health issues stem from a turbulent home life rather than social media usage. This case is considered a critical test for thousands of similar lawsuits accusing social media firms of intentionally designing addictive products with the potential to significantly change how these companies are held liable for user safety. The ongoing social media addiction lawsuits, especially the consolidated group known as JCCP 5255, are structured so that a few early cases act as bellwether trials. These trials help determine how thousands of similar claims may proceed. The K.G.M case is the first such bellwether. Thousands of plaintiffs, including minors, young adults, and parents, have sued major platforms like Meta, Google/YouTube, Snap, and TikTok. These claims were consolidated into a single judicial coordination proceeding, JCCP 5255. A consolidated proceeding like this groups together similar claims, streamlines discovery, exchange of evidence, allows consistent judicial rulings, and sets the stage for bellwether trials. Because all the cases argue that the company's designs intentionally created addiction in minors, the court needs a way to test the legal and factual issues without trying every case individually. According to reporting from PBS, K.G.M's lawsuit is the first individual trial to move forward within JCCP 5255, making it the de facto bellwether. Her case contains the core allegations shared by the broader group. She began using YouTube at age 6, and again I ask, why age 6 and who the hell was watching this kid? Anyways, and later Instagram, Snapchat, and TikTok. All of those, some adult, some parent, some legal guardian allowed a 6-year-old on all these platforms. We should be suing the parent. Anyway, she claims the platform's addictive designs cause severe physical and emotional harm. Physical? Okay, I'm sorry. I'm making little snide comments along the way. I just can't help myself. The case argues companies use techniques similar to slot machines in the cigarette industry to maximize youth engagement. Because these allegations are representative of the thousands of cases behind her, the outcome of her trial will inform how the others may resolve. What happens in a bellwether trial in this context? The jury tests the core legal questions. K.G.M's case asks the court to decide foundational issues such as, did social media companies intentionally design addictive features targeting minors? Were those designs negligent or defective? Did the company's actions directly cause the plaintiff's harm? These same questions appear across the entire JCCP. Therefore, the early jury verdicts offer a real-world test of how the evidence holds up. The trial reveals how juries perceive key evidence. The K.G.M trial will be the first time jurors hear expert testimony of the neurological impact of algorithmic design, comparisons to gambling addiction mechanisms, arguments about whether platforms targeted minors as a core market. Their reactions, favorable or unfavorable, become indicators of jury sentiment for all pending cases. It pressures defendants towards settlement. In fact, this pressure is already visible. Snap settled with K.G.M. days before trial. TikTok settled shortly after. This leads me to believe other people who want a money grab will call their nearest lawyer for their payday. Trials continue against Meta and YouTube, showing which companies were willing to defend their designs in court. Such early settlements are typically in bellwether processes. Companies often settle if they fear future adverse verdicts. How outcomes influence the remaining thousands of cases. Once the K.G.M. bellwether concludes, its effects include setting valuation benchmarks. If the jury awards substantial damages, settlement values for remaining plaintiffs typically increase. If the defense wins, plaintiffs may reconsider or reduce expectations. Guiding negotiations. The bellwether verdict acts as a negotiating leverage. Plaintiffs' attorneys and tech companies will use it when discussing potential global or batch settlements. Clarifying legal pathways. The case may clarify whether certain claims can survive First Amendment defenses, whether algorithms' design features constitute a product defect, whether companies can be held liable for youth addiction as alleged. Because the bellwether tests these questions in a real courtroom, the result informs strategy for all remaining suits. Why the K.G.M. bellwether matters nationally. This is one of the major trials to confront the question of whether social media companies can be held liable for designing addictive products aimed at minors. As PBS notes, this case could help shape future courts, analyze social media design, youth safety, and the limits of platform responsibility. The trial is therefore not just symbolic, it is a legal test case that has potential ripple effect across state legislatures, tech platform business practices, future federal regulation, and ongoing litigation involving youth harm. Why Snap and TikTok chose early settlement in the social media addiction bellwether litigation is a clear separation between what is documented and what can only be discussed as a general legal strategy. Because the reporting does not state explicit reasons for the company's decision, any explanation must distinguish between verified facts and generally accepted strategic motives in large-scale tech litigation. TikTok agreed to settle with the plaintiff just prior to the trial beginning, according to Matthew Bergman, the founding attorney of the Social Media Victim Law Center, which is representing the plaintiff, 20-year-old K.G.M. Snapchat had settled a week earlier, on January 20th, for an undisclosed sum. The PBS report on K.G.M. bellwether trial confirms Snap settled with K.G.M. shortly before trial. TikTok struck a deal with the following Tuesday. The terms of the settlement were not disclosed. TikTok remains a defendant in other personal injury cases in the same consolidated proceeding, the JCCP 5255. The article gives no further information about why Snap or TikTok settled. Thus, any explanation beyond this must be framed as general litigation strategy applied to this context, not as a factual statement about these companies' internal decision-making. Why companies commonly settle early in bellwether litigation? General but directly relevant. Although the article does not specify motives, bellwether litigation has well-known strategic dynamics. Here are the reasons that typically apply in cases like this and likely influence Snap and TikTok. To avoid a public jury verdict that could set an expensive precedent. Bellwether trials signal to all parties how juries react to central allegations. That social media platforms intentionally designed addictive products targeting minors. If a company fears an unfavorable verdict, an early settlement prevents a public finding of liability. It damages benchmark that could inflate costs in thousands of related cases. Momentum for plaintiffs across the consolidated litigation. This dynamic is specifically important here because K.G.M.'s case is the first bellwether in a massive coordinating proceeding, the JCCP 5255. A loss at this stage could negatively shape future negotiations for defendants. To limit negative publicity related to youth harm. The K.G.M. trial revolves around allegations that platforms use design features modeled on slot machines and cigarette industry techniques to addict children. This is high-risk optics for any company. Early settlement allows a defendant to avoid inflammatory courtroom testimony, prevent internal documents from appearing in open court, and keep harmful narratives from dominating news cycles. Given the subject matter, children harmed by alleged algorithmic manipulation, public relations risk is unusually high. To reduce litigation costs, bellwether trials involve enormous discovery demands, expert testimony, and multi-week courtroom proceedings. When thousands of similar cases exist, settling one one representative case can minimize legal spending, expert witness costs, document review burdens, and in-court exposure. Snap and TikTok may have judged that the cost of trial outweighed the cost of confidential settlement. To preserve strategic flexibility for remaining cases, the PBS report confirms that TikTok remains a defendant in other personal injury cases even after settling with K.G.M. This suggests a typical bellwether strategy: settle the most visible or earliest trial case, avoid an adverse ruling that strengthens plaintiff's leverage, continue defending remaining cases individually, or negotiate from a stronger position. By settling early, TikTok and Snap may maintain more control over how later cases unfold. To avoid strengthening plaintiffs' arguments about addiction-based design, the lawsuit argues that social media companies specifically targeted minors as a core market, used behavioral and neurobiological techniques used by slot machines, and designed their products to be intentionally addictive. If a jury found this persuasive, the ruling could be profoundly damaging, not just legally, but to the fundamental business models of these companies. By settling, the company avoids a formal legal judgment confirming harmful design practices. Plaintiffs are not given a powerful early trial victory to cite across the entire JCCP 5255 docket. Why Snap and TikTok likely settled early? They settled shortly before trial. No reasons were disclosed. Based on established bellwether litigation strategy, to avoid a precedent-setting jury verdict in the first bellwether trial, to limit reputational harm from public testimony about child addiction, to manage litigation costs and avoid broad disclosure, to retain strategic control over thousands of remaining cases, and to avoid strengthening plaintiffs' claim about intentional addictive design. The ridiculousness of this lawsuit and the others in the JCCP 5255 is beyond my personal comprehension. For a 6-year-old getting on social media or playing in traffic, it's up to the parent to regulate this activity and protect their child. This is not society's job, and this is not social media's job. Parents, it's your fucking job. Do your job or don't have children. And if you're an adult and you're addicted to Facebook or TikTok or alcohol or cigarettes or gambling or video games or television or food or so on, that is your fucking problem. You be an adult and you deal with it. There are more than enough outlets in this country to seek help towards any imaginable addiction. The fact you need to sue companies for your own fallacies is mind-numbing. It's like this whole voting debate with the SAVE Act. You have grown adults bitching and moaning how difficult it is to get a birth certificate or change their name when it's easy as fuck. You can order a birth certificate right online. It's your problem if you don't have one. You lost it, you misplaced it. That's not society's problem or government's problem. That's your fucking problem. And if you get married by law, you take your husband or wife's or whoever you marry's last name, you're supposed to let Social Security know. And you also have, in 99.9% of the cases, a marriage certificate. Be an adult. If you don't have these things, go get it. Out of all the stupid things you probably purchase, I think you can spend a few bucks on a birth certificate. If you're homeless or on social services, a social worker should be able to draft an affidavit in order to get your proper documentation at no cost. There are outlets. You need to be an adult and utilize them. You need to show some effort. This is no different than this stupid lawsuit. If you're an adult, exercise self-control. If you're a child, a parent or guardian should be monitoring what you're doing. You didn't get a hold of that computer or smartphone by osmosis. Someone who is an adult gave that to you or allowed use of it to you. They can take it away just as easily. And I'll assume this K.G.M had access to one or the other at age 6. Who the hell is giving access to a 6-year-old and not showing interest in the amount of time they're spending on social media? Come on, adults. Be adults. I know, it's hard for a lot of you, but that's not social media's fault. If it inconveniences you, then also tough shit. That is life. Life is one big inconvenience sometimes. Deal with it.
I think modern parenting over the last 20 years has softened so dramatically that many parents are mad at TikTok and Instagram and social media without realizing they have 100% control of deleting it off their child's phone. They have 100% control of taking their child's phone away for a month if they choose to. So guiding my children, for me, it's actually paying attention and caring to what they're consuming. I think parenting in 2023 has become too passive, has been too conducive to being your kid's friend instead of your kid's parent. And I would argue that until we get back to full accountability, we will continue to blame politics, the mainstream media, social media, TikTok, Facebook, and we're blaming, yet every parent that's watching this right now has control because they're the parent. So my point of view on this is parents need to step up in a significant way, be willing to be inconvenienced of their child being upset with them, and actually parent.
The only reason I bring the voting thing up and the SAVE Act is if adults can't be adults, how do we expect them to take care of their children? If the adult is a lazy moron, it only means that more than likely their offspring are going to be lazy morons and sue social media companies because their parent or guardian didn't do their jobs. That's not Mark Zuckerberg's fault. That's a so-called adult's fault. Sue your mother. No, can't do that. There's no money in it for you. You gotta sue the corporation. Millions and millions of dollars there. And that's where my very cynical part appears, like Bruce Banner turning into the Hulk. I personally believe, and of course all of this is just my opinion, that all these lawsuits are a cash grab. A cash grab for the lawyers and a cash grab for their clients. All this bullshit has been done before with music, comic books, television, video games, and so on. Either you have some religious nut out there suing some media company for Jesus, or you have someone who wants a payday, and that's all this K.G.M lawsuit is about, in my opinion. It's about give me money I don't deserve. It's the American way. We've seen it with the people wanting their college loans paid off to prestigious colleges, actually taking money so their child can attend under the varsity blues scandal. So in order to try to be somewhat unbiased, although you know where my opinion lies in this case, with the K.G.M about this being a money grab, as far as the information provided, no, the available reporting does not support the idea that the lawsuit is just to make some money. In the K.G.M case, the plaintiff argues she suffered I don't get the physical part, and emotional harm after becoming addicted to social media platforms beginning in early childhood. Is she doing somersaults or cartwheels while she's on social media? Is that where the suffered physical harm came in? I don't know. This may be true. Again, I reiterate, that's not social media's fault. That's the parent who should be monitoring what the hell their child is doing. But I digress and I continue. In the Selena Rodriguez case, the mother alleges her 11-year-old daughter died by suicide due to the addictive design of Instagram and Snapchat. The lawsuit claims that platforms were dangerous and defective and exploited children psychologically. 11-year-old daughter? What are you doing, parent? Are you not monitoring what this 11-year-old is doing? How much time they're spending on social media? How much time they're spending on anything? What other psychological issues or what other issues are feeding her psychology? I'm not saying these people don't have depression, don't have anxiety, don't have other psychological issues. I have depression. I have anxiety. I take medications for it. I can't get through the day without them. But it's me. It's inside me. I don't know how to fix it. I've been to therapy. As I mentioned, I have medication. I do the best I can. I don't blame anyone for it. Sure, there's things like alcohol that can contribute to it, but then stay away from that stuff. Alright, anyways. These reported harms, addiction, emotional jury, hospitalization, suicide, are serious and not merely financial grievances. Yeah, they're all serious, but you don't blame social media for them. Alright, I already did a video a while back addressing the congressional hearing about kids taking their own lives over social media, and I will link that down in the description. Take a look at it. The central allegation in the K.G.M. Bellwether trial is that companies design products using techniques similar to slot machines in the cigarette industry to hook minors for profit. This frames the suits as challenges to corporate conduct, not quick financial grabs. Social media is not there out of the kindness of their hearts. Either are movies, television, video games. They're all businesses, and businesses generate revenue. This is no fucking secret. These cases are part of large, coordinated litigation, not individual opportunistic suits. I tend to disagree. The K.G.M. case is part of a consolidated group of thousands of plaintiffs, the JCCP 5255, meaning it was not filed in isolation. It underwent judicial review and selection. As a bellwether, it represents widespread concerns across families nationwide. Bellwether trials generally involve systematic allegations and large-scale harms, not one-off attempts to gain money. Financial compensation is normal in injury lawsuits, but not the sole purpose. in personal injury or wrongful death litigation, seeking damages is standard, even when the main goals are accountability, industry behavior change, public disclosure of internal practices, and safety improvements for children. The lawsuits here ask courts to determine whether social media companies should be legally responsible for harms tied to platform design. That question is distinct from the motives of greed. Yeah, what about the greed of the plaintiff? Plaintiffs often seek policy change and recognition of responsibility. The themes across the reporting include addiction to children, mental health damage, unsafe platform design, allegations that companies prioritize profit over child safety. These are public interest issues far larger than monetary compensation. So is the lawsuit just to make money? Based on the facts available in reporting, there is no evidence that these lawsuits are simply attempts to make money. Again, this is not my opinion. This is what I'm getting from the information that I've researched. They center on child safety, suicide, addiction, and alleged corporate negligence, serious issues documented in multiple news sources. Let's say that the last statement is all true. The world, society, government, corporations are not responsible for your child. You are. At the end of the day, you are the parent, and it's your responsibility to protect your child, especially in this particular instance, as it's so incredibly easy to limit social media, smartphone, and computer time. That is a parent or guardian's job, not Zuckerberg's. I had trouble with alcohol once upon a time to the point of addiction. I lost my marriage, jobs, and pretty much my life to it. I didn't blame Smirnoff or my local liquor store. I was an adult, so that was on me. There was only one person to point the finger to, and that was myself. I went to inpatient and outpatient treatments. I went to counselors for addiction and the reasons for the addiction. My friend's father had an alcohol problem, probably a bit less than myself, and he got over it. He sought other outlets to deal with that addiction. His wife had, or has, I'm not sure where that sits right now, but she didn't go and sue the casino. My buddy was a heavy dude. He was fat and got some of his stomach taken out. That's pretty extreme, but he loved the food. In my opinion, he was addicted to food. The dude could eat. He didn't sue anyone over it. He didn't go to McDonald's or Burger King and sue them. Of course, these are just some examples and addictions I am familiar with. There are a gazillion addictions out there. People have addictive tendencies, to be it alcohol, drugs, gambling, food, video games, working out, and the list goes on to infinity. Those are all personal responsibilities. If you're 18 or less, I say it's the parent or guardian's job to regulate that activity, and when a human being reaches teenage years, they need to start taking responsibility for such actions. When you reach 18, you're considered an adult, and that's on you if you are having issues with an addiction. That's on you to set limits or seek help. And that is my final word on this. This lawsuit and others like it are absolutely ridiculous. A lot of you probably think differently, and I certainly encourage any comments aiming either way down in, well, the comments. I shall leave it at that. Please subscribe to the channel. I thank you as always, gals and guys. Please like if you like this, share it with as many people as you can, and hit the bell for updates. And as I close out this video, I'll be adding to it the latest on the case. So I wrote that whole thing like a month or two ago. It took a while to edit through it and get it going. And in the meantime, while I was editing everything, a verdict did come in a couple weeks ago, and she won. K.G.M won. She won, according to this, $6 million. So it pays to be an irresponsible human being. I don't know. I'm very surprised at the verdict. I think it sets a precedence of everyone and their mother coming out of the woodwork and saying, "Oh, I've got mental problems, and it's social media's fault." So I just stubbed my toe. It's social media's fault. So give me a couple $1 million. And I don't know. It's no skin off my ass. It's not my money. So it's not like I'm overly upset about it. I'm just surprised, and personal responsibility goes out the window. Welcome to the United States of America, where personal responsibility is almost nil. No one has it. It's always someone else's fault. And that's what surprises me about this case. So, oops, right here. So they were found negligent. I believe YouTube and was just reading it. YouTube and Meta, of course. YouTube had to pay a minimal amount. Meta had to pay most of it. They're the bad guys. I mean, again, the same thing happened with comic books and video games. Not to the degree of the amount of money that's been paid out. A 6-year-old girl. Why is she on social media? And why isn't anyone talking about the mother and there's personal responsibility that she has? No one's saying that. The media is not saying that at all because social media is the bad guy. Not big advocate of Mark Zuckerberg. I could care less. I've had problems with Facebook before. I'm not a big fan of his. But still, it's crazy. Here it is right here. Jury decided on $2.1 million in punitive damages for Meta and $900,000 for YouTube, totaling $3 million, small fraction of $1 billion in punitive damages to plaintiffs' counsel sought. And then this says $6 million, so I'm not sure. Oh, here it is, liability, Meta, Instagram, 4.2, and then YouTube. This has changed. This is different than what the article says, so it doesn't really matter. All right, guys and gals, that was the verdict. I said pretty much what I needed to say. I went through the whole case, kind of broke it down as much as I could to get an understanding for myself and hopefully you folks out there. It'll be interesting to see what happens down the pike here as everyone comes in for their piece of pie and what happens to these companies. I doubt too much is going to happen to them. They make a lot of money. And yeah, that's it. I'm not gonna lay on this too much. Surprised? I'm surprised. It's just like the SAVE Act, and I don't know. It's just no one's got responsibility. Everyone wants money from some other entity. It's never their fault. And that's the way the world works, I suppose. All right, guys and gals, I am done here. I'm going to edit this up and put it online. And once again, if you could subscribe and share and like and hit the bell for updates, whatever the hell else you have to do on this thing, I appreciate you. And yeah, I'll catch you later. Peace.